Your Honor, if I may again.
You may what?
Your Honor, as stated on the record earlier, I just tried
Sit
to
down,
Your Honor. Okay.
I'm not going to tell you again. You may think you're a lawyer. You know, everybody today that has a computer and a finger that can type thinks that they're an attorney because they can go on the internet. One more word out of you until I offer you the chance to speak. You're going to be in contempt. Okay, this is case number 25 CV 198, Gloria J. Greenlee et al. Versus James Stephen Petro. And Mr. Judkins is appearing on behalf of the defendant, James Stephen and Joyce Petro. The plaintiffs are pro se. All right. Are you Gloria Greenlee?
Yes, sir.
All right. And you are Kyle Greenlee, and you are Micah Greenlee? All right. All right. The matter then before the court is a motion for leave to file a supplemental complaint that was filed May the 8th. All right. So, Ms. Greenlee, you'd like to explain to the court why you feel that the motion should be granted?
Yes, Your Honor.
I didn't say you, I said Gloria Greenlee.
Yes, Your Honor.
Okay. Remember, you're not an attorney.
Yes, Your Honor. It's hard to hear in here because the vans.
All right, I'll speak up. Gloria Greenlee, I'd like you to explain to me why you believe that this motion is appropriate.
Okay. I wasn't prepared for that because.
You're going to have to speak up.
Okay. Yeah, well,
Go turn off the fan, please.
I wasn't really prepared to say anything today because actually Kyle prepares the paperwork.
You prepared the paperwork and you signed it?
Yes.
All right. Is that the same thing with you, Mr. Micah Greenlee?
Yes, Your Honor.
All right. Well, Mr. Kyle Greenlee, I made this statement at the last hearing that we had that you cannot advocate and represent anyone but yourself, since you're not an attorney. And so you have engaged in the unauthorized practice of law by preparing documents that they are signing.
That is incorrect, Your Honor.
No, do not argue with me. I'm telling you right now, it's as plain as the hand in front of my face right here. They're signing off everything you do. She just said you do the paperwork. All right? So that's unauthorized practice of law. The motion also, you filed another motion here, or in your motion, asking to, on behalf of Rebecca Greenlee, and she's not a plaintiff in this case yet, and you cannot advocate for her.
I'm not advocating for her.
You are. You're filing, you're preparing. One more word out of you until I offer you the chance to speak. You're going to be in contempt. All right? Now, you keep your mouth shut. When I'm ready to hear from you, I'll give you the chance to speak. Now, this is not a discussion. This is a statement and an order. You are to cease and desist from filing anything in this court other than with your name on it. Mrs. Greenlee, Mr. Greenlee, Micah Greenlee, you are not to sign anything that you did not prepare yourself and file in this court. If you sign off on something that Kyle Greenlee did, you're going to be witnesses against him in his unauthorized practice of law case because he will be reported to disciplinary counsel. He cannot prepare documents for you. Every time you sign a document or a pleading in this case, you are signing it the same as any attorney would and be subject to the same sanctions and penalties for filing something that may be considered inappropriate. And so that puts you at risk. So you do not sign anything that he prepares. If you want to file anything, if you want to represent yourself, you're entitled to do that. All of you. Only yourselves. And that means you, Mr. Greenlee. Anything you file has to advocate for you. So I will not accept in any pleading that you file from this point forward that argues on anything on behalf of Gloria Greenlee or Micah Greenlee or anyone else in the case will result in the court filing a report that you are engaging in the unauthorized practice of law. This whole thing started off with Miss Greenlee, as according to the complaint, being the tenant to sign the agreement. No mention of you or from my understanding, your residence. So you have only the right to advocate for violations or claims or remedies that apply to you individually and not to anyone else. Do you understand that?
Your Honor, may I speak?
No. I said, yes, you may answer my question. Do you understand?
Yes, Your Honor, I do.
All right,
Now, may I
very
speak?
good. That's good. That's all we need. All right, because that's the rule, and that's what's going to be followed.
Your Honor,
Whether you like it or not, that will be followed.
May I speak, Your Honor?
No. I've just told you. You are not going to engage in unauthorized practice of law in this case.
Your Honor, I've been doing this for over 16 years in Montgomery County Common Pleas Court, the federal court. At this point, I'm about to certify this to the federal
Are you a
court.
licensed attorney?
No, Your Honor, I'm not.
You're not. So you're
But
not
I can-
qualified to represent anyone else. That is the law in this state. I don't care how familiar you are with the law. It is not grounds for you to represent your family. You cannot do it. It's the law.
Your Honor, I'm not representing them.
I don't care what happened anywhere
Okay.
else. You know, my dad used to say 2 wrongs don't make a right. 1,000 wrongs don't make a right. Okay? Now that's the ruling of the court.
Okay.
All right. Now,
We'll go ahead and certify this to the federal court, Your Honor.
pardon me?
I said we'll go ahead and certify this to the federal court, Your Honor.
Well, you'll have a hard time doing that because there's no grounds for that.
There is.
It doesn't involve diversity of citizenship. So, in any event, now, you may speak on behalf of yourself regarding this motion.
And I am, Your Honor.
All right, go ahead.
So the facts are all the same. Whether
Stand up and address when you address it.
Your Honor, the facts are all the same whether it is my filing, their filing, and who signs off on it. So since the filing of this lawsuit, Your Honor, Cheryl Fetro, her real name Brenda, she goes by Cheryl, and her husband Brian have decided to involve themselves in this case. Since the filing of this is involving both federal and state laws for housing discrimination, Your Honor. They have now decided that because of the filing of this action, that they are going to try to evict us from the property. Your Honor, that is retaliatory discrimination in violation of ORC 4112.02I. So ORC 4112.02J, as stated in the motions, it is unlawful for anyone to aid, abet, coerce, pull that right back.
Let me interrupt you. Who's the owner of the property, title owner of the property?
That would be Steve Fetro and Joyce Fetro, Your Honor.
And who?
Joyce Fetro.
All right. So they're the owners.
That is correct.
All right. So they would be the ones who would have the right to seek an eviction. All right. So they're both already parties to the action. So how is it that people that are not parties to the lease could be held responsible for violations of the landlord-tenant law?
Your Honor, there is no written lease. It was an oral.
Pardon me?
There is no written lease. It is an oral lease.
Okay, yeah, I understand that.
Right.
Yeah. Oral or written, it's a lease. And that lease was between Gloria Greenlee, Rebecca Greenlee, who later left and is not a party, and Mr. Fetro. Is that correct?
That is correct, Your Honor.
All right. Now go ahead.
So, Your Honor, since that time, Cheryl has, along with their attorney, which should have known that it is unlawful to aid, abet, coerce, entice, or to act directly or indirectly in any manner to discriminate against someone else. That is pursuant to ORC 4112.02J. Your Honor.
What's the discrimination?
So the discrimination, Your Honor, as it is stated in the complaint, is that we were made to pay rent, or Gloria here and Rebecca was made to pay rent, while tenants up front, being that of Greg Wiley and...
Okay, I'm sorry. You're basically just saying that these new people that you want to join have committed the same acts that are alleged in your complaint? 411202, 532113, etc. Is that correct?
Yes, Your Honor, and they have now engaged in
Okay,
retaliation.
so that's the basis for your request, all right? Go ahead. Is there anything else in that?
Yes, Your Honor, their
And
actions...
explain to me again how that affects you.
Your Honor, I do live in the premises,
Okay.
along with Micah Greenlee.
You live in the premises,
That is correct, Your Honor.
but you're not a party to the lease.
I was not a party to the original oral agreement, no, Your Honor.
Okay. All right. Anything else?
That is all, Your Honor.
All right. Thank you. Mr. Judkins? Excuse me. Mr. Heath Fetro, are you a party to this action?
He's the power of attorney for James Stephen Petro.
Oh, okay, he is a power of attorney.
He's power of attorney for James Stephen Petro.
I'm sorry, I neglected to get that. And I'm sorry, your name?
I'm Cheryl. Cheryl Flugerman.
All right.
She's who is subject to the request to add as a party.
Right, okay. All right, thank you. Should have done that at the beginning, sorry. All right, Mr. Dickinson.
Just 1 second here. I got to take a note of what was just said here just a moment ago. I think that's relevant. There are two pending motions here before the court. A motion for leave to file supplemental complaint and a motion for injunctive relief. I'll deal with them each in turn.
That was actually just filed on the 26th, and I haven't actually set that for hearing.
I believe we have a motion for injunctive relief that was also filed on May the 8th.
Oh, okay, it was? Wait a minute. I'm sorry. I was busy before I came in here. I did go over this yesterday. Yes, it was. I'm sorry. All right, go ahead.
Okay. So the motion for leave to file supplemental complaint seeks to, in its body, while it's not captioned this, in the body it seeks to add a party to this case of Cheryl Fetro here, based on some various allegations, and then seeks to add a handful of other causes of action, including defamation and retaliation. Ultimately, the causes of action that are sought to be added against Ms. Fetro-Flugerman have no relationship to the first complaint or the first cause of action. They're entirely separate. They're based both on the contents of the motion as well as the supplemental affidavit that was filed in support of the motion on actions that occurred during the pendency of this lawsuit but had no direct relationship to the lawsuit, just comments about it. If they support a cause of action, they support an entirely separate cause of action. And by joining them as separate counts in this complaint, it would both goof up the ability to get this thing tried on time because there'd be need for a whole new round of discovery. Ms. Cheryl would need to get caught up on things and hire her own attorney, and it would be a disaster to slow this case down to add in what is essentially unrelated claims based on separate actions taken that do not directly relate to this underlying cause. And that it just makes no sense. If it supports a claim, fine, file it as its own lawsuit. But that has no business being joined in on this pending cause of action. As to the motion for injunctive relief, it is confusing exactly what they're asking for because you can't really enjoin people who are not party to the lawsuit from doing things, and it asks to do that. Additionally, it seeks an injunction based on a defense in the Landlord-Tenant Act. It's if there is evidence to support a violation of the Landlord-Tenant Act, that is appropriately brought as a defense in an underlying eviction. As Mr. Greenlee correctly pointed out, there is now a pending eviction in the municipal court, in the Hillsborough Municipal Court. If these actions occur, he believes that they were retaliation in violation of the Landlord-Tenant Act, he has every right to raise them as a defense in that eviction action. But to have this court issue an injunction that would interfere with another court's pending lawsuit that would prohibit the parties from pursuing legal relief in something that is not before this court itself is absurd and beyond the pale. And so we'd ask that both motions be denied.
All right.
Your Honor, if I may again.
Just a minute. I'm in charge here. I know how to do this. I've been doing it a long time. I'll get to you when I'm ready. All right. Now, you may respond only as to how it affects you.
Yes, Your Honor. As it affects all of this, This
No,
was-
only as it affects you. You cannot advocate on anyone else.
I'm not advocating on
You
anyone
just
else.
said as it affects all of us. So
The facts are the facts, Your Honor.
As it affects you.
Confine your remarks to your position in this case because it is potentially separate from the other parties.
So, Your Honor, the facts of the case are the facts of the case. And this case is being brought under the Fair Housing Act discrimination. So there have been two tenets that have lived up front. One is age discrimination. The other one is race, age, and sex discrimination that do not pay rent. They have not sought any illegal eviction action against them. They have only sought it against us. The whole entire premise for their eviction action is for the filing of this lawsuit. It is proven through Cheryl's Facebook post and a subsequent text message that was sent to my sister 1 month after the filing of this lawsuit, Your Honor, which will be filed by my sister in an affidavit that will be coming this week, later next week. Your Honor, as far as it being any kind of defense in an eviction action, it is very clear that this is retaliatory discrimination. So by law, there are 4 things that need to be proven for a prima facie showing of retaliatory discrimination. That plaintiffs engaged in a protected act under Chapter 4112, under Chapter 4112 of the Revised Code, Your Honor. That would be filing of this complaint. So, ORC 4112.055.
Are you a named party in that complaint?
I'm sorry, say
Are
that
you a
again, Your
named
Honor?
party in the eviction?
I am yes, they have the
All right.
eviction as well, Your Honor.
All right, thank you.
So under 4112.055A, Your Honor, it does authorize us to file a complaint for housing discrimination with the Court of Common Pleas in the jurisdiction in which the alleged violation occurred. So that has been done. We are now protected under that act, Your Honor. So the protected act has been engaged in. That the defendant knew of the protected act. Obviously, they were served with it. They are here arguing against it today. 3, that there was an adverse action. The adverse action, Your Honor, is that the attempt to evict us for nothing more than this lawsuit, which is in the causal connection, Your Honor. So that is why we are seeking injunctive relief to stop them from doing so. At this point, it's going to be hard for them to prove in court anyway because none of them were party to the original lease. So anything that they would have to say in that court would be hearsay, Your Honor. As it has been brought up as well, there were power of attorneys, which now need to be added to this case as well.
When was that action filed?
Yesterday.
Which, Your Honor, if I may, again, after the filing of these motions and obviously after the filing of this complaint.
Yeah, that's evident. All right. Well, the court does not have jurisdiction to interfere and prohibit another court that has jurisdiction of the forcible entry and detainer, which is the municipal court by statute, from proceeding. It is a defense, as Mr. Judkins has pointed out, to that action. But I don't have the authority to enjoin another court from exercising its jurisdiction. And so that claim is denied. And in terms of the other request for the other parties, Petro Flugerman is not a party to the original action. It's my understanding that, from my reading of the motion, that apparently she runs a business, a beauty shop, and that Miss Rebecca Greenlee rents a booth in that shop and is being attempted to be evicted from that. That would be something that's totally unrelated. I mean, regardless of the motivation, it has nothing to do with this case. Miss Greenlee is not even a party to this case, and it's a totally separate matter. So the court will not join or grant the motion, or deny the motion in its entirety. Ms. Flugerman is not a proper party in this case. She may be a witness, but she's not a proper party. Nor is Mr. Judkins as an attorney representing people. He's not subject to being sued for acts that his clients are doing. That's his job to advise them or defend it, and if the appropriate ruling will be made by a court of competent jurisdiction. And based on that, a motion for filing a supplemental complaint or amending complaint is denied. All right. And then in terms of injunctive relief, the same thing. The court is going to deny that because I don't have the jurisdiction under 1 to prevent another court from seeking relief, and nor do I believe I actually have the authority to enjoin a party from seeking to exercise relief to which they may or may not be entitled. That's the whole purpose of the proceeding, is to determine if they do have a right for the premises, restoration of the premises, and as indicated in Mr. Judkins' argument, which I think is correct, is that it is a defense. You can raise those in that action. The claims in this action are based upon the violations that are unrelated to the eviction, and that's something that has occurred since then, and it will be something will have to be determined in a separate case. Now, there is also a motion filed on behalf of Ms. Greenlee, which I'm guessing Mr. Kyle Greenlee, you prepared this too?
No, Your Honor. She did prepare that herself. She is not here today because she was not ordered to be here today.
Well, no. Her hearing is not on her case isn't on the agenda. But I note that her motion asked for to be enjoined in this action as a plaintiff. And so I'm going to deny that motion because she enjoined means to bar, prohibit, stop, or cease some action. And so, therefore, there is no authority under the law to enjoin somebody who's not a party to the action. So she's not a party in the action, and so she cannot be enjoined from anything. So the motion is denied. All right.
Your Honor, if I may again.
You may what?
Your Honor, as stated on the record earlier, Rebecca Greenlee was a
You cannot advocate for Ms. Greenlee. Sit down.
I just tried
Sit
to
down.
Your Honor. Okay.
I'm not going to tell you again. You continue to argue on other person's behalf. You may think you're a lawyer. You know, everybody today that has a computer and a finger that can type thinks that they're an attorney because they can go on the internet. Same like you can be a brain surgeon and go on the internet. You know, you're not. You're not an attorney. You cannot practice law, and you cannot advise or advocate for anyone else, and you're not going to be allowed to do that. And if you continue to do that, two things are going to happen. One, I've told you repeatedly not to do it. I'm going to hold you in contempt. Two, I'm going to file a complaint with disciplinary counsel of the state to allege that you are engaging in the unauthorized practice of law. And as someone with 50 years experience, I can tell you that what you're trying to do is clearly engaging in the practice of law. You cannot advocate for others. You cannot prepare documents for others. You cannot seek to get relief for others. And that's exactly what you're doing. This is exactly what you're doing. It's clear to everyone. And whether you admit it or not, it is clear. And I don't know what you claim about what you've been allowed to do in Montgomery County, but if judges up there allowed you to do it, shame on them. Shame on them. They were wrong too. Shame. Well, the federal court maybe be a little bit different in terms of advocating on your own, but I don't know. You're not allowed to practice law without a license in federal court either. All right. Now, that takes care of all the pending motions. And any other pending motions, judges?
No other pending motion, Your Honor. But I would like, just while we're all here, for an opportunity.
Okay.
There is outstanding discovery that was propounded by plaintiffs. There was a grant informally here of an extension of time here to respond to that discovery. That extension of time has
from whom? I mean,
so plaintiffs granted an extension of time to defendants to respond to discovery.
Okay.
That extension is now expired here. We've not yet pursued a motion to compel or anything like that. Haven't even followed up with an additional email indicating that that has occurred yet. But with trial coming up here within a month, I wanted some guidance from the court as to what the court would expect for motions to compel, as far as how much time the court would want to rule on such a motion.
Well, I know you just entered the case, and not been any activity in the case until the recent filing by the plaintiffs in May, and so everything is pretty well, other than the final pretrial. I mean, the discovery has elapsed. Now, if you want to agree to some modification of that between yourselves, I have no problem with that. If you want to, if you're not able to agree and you want to, either side wants to file a request for extension, the court would probably view that favorably. And in all honesty, with you being new in the case, if there's a interest in getting an extension to allow discovery on both ways, it works both ways, and I don't know if you requested discovery or not on your own behalf, Mr. Greenlee. But the court would look at that favorably, because discovery would obviously help move this case along in trial. So I guess that's what I'm saying is I'm open to, modifying the schedule if the parties want to agree on something, or if you're not agreeable, if you want to bring a motion before the court, because there are no motions to enforce discovery either way. So I guess that's however you want to do that. Or if you just want to go ahead and proceed to trial on the 7th without discovery, because everything's been waived, that's fine too. I mean, it's up to you guys. So you want to talk about that?
Your Honor, there was actually a conversation that was had between us and counsel for an agreed-upon motion to continue for the discovery. There's an email regarding that as well. So counsel's not very forthcoming about that. We can discuss it, and we can agree and file it with the court, Your Honor.
Well, I have a few minutes here if you want to talk, and then we'll come back on record, and I get a calendar now. Or,
when are you going to be able to get the responses on the discovery? It's been over 2 months at this point.
Oh, well,
So last time you said you need 2 weeks.
So it wasn't 2
are you
months
talking about discovery that the defense requested of the plaintiff?
Discovery, I'm sorry, discovery.
I thought you meant discovery they had requested of you.
The other way around.
The other way, okay.
The discovery that the defense requested of the plaintiff.
But, Your Honor, we did have a discussion on that as far as filing a joint motion to continue for that, which if I do need to file an affidavit with that email, I will do so.
So I'm in the affidavit. I'm just saying is if you guys want to agree on something, fine. Yes. Otherwise, file a motion, and I'll look at it. And again, I'm inclined to be approving of extensions so that discovery can be completed on both sides if you want, and allow, because again that will help, I think, in terms of narrowing the focus of the trial and the issues in the trial potentially. It seems to me it would be beneficial to both sides. But again, why don't we take a break? You guys talk for 5 or 10 minutes, and then I'll come back on, and I'll bring the calendar in. And if you have an agreement, we'll get some new dates. And if not, then we'll just go ahead and stick with the original date unless somebody files a motion.
Your Honor, can we also extend the time for dispositive motions?
We'll talk about that.
Okay.
Yeah, we can talk about the whole thing, because quite honestly, I was a little surprised that there hasn't been any motion activity other than what you filed regarding the proceedings. So again, that would be beneficial, I think, to everybody, because it would help potentially maybe narrow the issues, or at least get understandings of what the issues will be at the trial. So we'll go off the record and take about 10 minutes here.
This courtroom hearing quickly turned tense when a judge confronted a man who was attempting to speak and file legal documents on behalf of his family members without being a licensed attorney. The judge made it clear from the very beginning that only licensed attorneys can legally represent other people in court. When Kyle Greenlee admitted that he had been preparing documents for family members involved in the lawsuit, the judge warned him that this could be considered the unauthorized practice of law. As the hearing continued, Greenlee repeatedly tried to explain his position and argue legal points. However, the judge repeatedly interrupted him, reminding him that he could only speak for himself and not for anyone else involved in the case. The situation escalated when the judge warned that any further attempts to advocate for other family members could result in contempt of court and even a formal complaint to state disciplinary authorities. Throughout the hearing, Greenlee argued that he had experience handling legal matters for years and claimed he was not officially representing anyone. But the judge disagreed, stating that preparing legal documents and seeking relief on behalf of others clearly crossed the line. In the end, the court denied the motions that Greenlee and his family had filed, ruling that the requested claims and injunctions were either unrelated to the original case or beyond the court's authority. The hearing serves as a reminder that courtroom procedures are strictly governed by legal rules, and even extensive personal legal knowledge does not replace the qualifications required to practice law.